When we talk about self-determination with tribal nations, it's important to understand the difference between self-determination in indigenous education and the self-determination that we discussed with W.E.B. Du Bois and African American education. In both situations, this idea of being able to self-govern on your own terms, for your own interests, and from your own perspectives and ways of knowing the world, that's present for both. However, with tribal nations, there's the additional issue of sovereignty that is a political and legal status, and that is an important framework for any conversation about Indigenous education. So in the United States today, there are 561 federally recognized tribes, and there are hundreds more that are recognized at the state level or who are still fighting for recognition. And when you talk about being recognized, what that means is the federal government acknowledges a government-to-government relationship with that tribal nation. And this becomes important because it is the legal and political basis for the relationship, and it articulates the different boundaries or parameters of the relationship. And all of this is located in treaty rights. So some of the history that laid the foundation for defining this relationship comes from the Supreme Court and the decisions that are usually called the Marshall Trilogy. So Marshall and the other Supreme Court justices in the 1820s and 30s were really operating from the Southeast United States context and during the time of Indian removal. So how they were basically laying this out is with that first court case, they were saying that you have to have title traded only through the government. You couldn't just sell indigenous land to an average farmer directly. It had to be mitigated or mediated by the federal government or Congress. With the Cherokee Nation, they also added more power to the federal government and made it central to the relationship with tribal nations by this concept called domestic dependence. So what it basically said is, yes, we are both governments, and yes, we both have a relationship, but the federal government is kind of the father to the child, and the child, of course, in this is the tribal nation. So it's a paternalistic relationship, and it really puts a lot of limits on the sovereignty of the tribal nation, even as it continues to affirm the relationship as a nation. And Worcester versus Georgia, it basically does just that, where it affirms that nation-to-nation relationship and tells the states that they actually have to take a back seat to a tribal nation unless Congress says otherwise. So a different way to look at the structure of the relationship is in this graphic, which is that tribal nations are in a lot of ways on an equal footing with the federal government, and states are actually below them. And the power for these relationships comes from the federal constitution and the treaty rights that were articulated through the federal constitution. So when you talk about what a treaty is, it's a formal negotiated agreement between governments where each are agreeing to basically constrain parts of their sovereignty and take on certain responsibilities or obligations. And these treaties are the supreme law of the land. They become part of the Constitution in that sense. So state laws cannot impact or undermine a federal treaty. So when we talk about tribal nations and treaty rights, especially when you talk about things like hunting or gathering, there's a lot of confusion about what a treaty does and does not do. So with treaties, it's not that the federal government gave tribal nations the right to hunt or fish. It's that the tribal nations held back that part of their rights when they were negotiating other things. So the treaty doesn't give the right. It simply says this right remains and is still possessed by the tribal nation. So when you think about Collier and American Indian education, we have to understand that whole legal context of a nation-to-nation relationship as sitting right there in the middle of his project. So the Dawes Act is kind of the big policy that also was providing a context for Collier. The Dawes Act, or the Allotment Act of 1887, was this kind of scientific management idea that broke up communally owned tribal land and distributed it individually. So what they're talking about here is a shift into an assimilated capitalist individual who no longer has a relationship to the political entity of the tribal nation in the same way. It's an assimilation mechanism in terms of creating a yeoman farmer or individual farmer, but it also is a land grab. It is breaking up collectively held land and distributing it in order to kind of free up, quote, extra parts for the distribution among white farmers. And so you can see in this map that there's a significant shift in ownership between the beginning of the United States and the time right after the Dawes Act. Obviously, all of that land shift was not a result of the Dawes Act, but rather this is intended to just show that tremendous transfer of land in a little more than 100 years. So if you look more specifically a little close to home, you can see that this had a huge impact. If you look at Wisconsin, for example, by 1935, about 57% of land that used to be in tribal hands shifted out of their hands. In Minnesota, over 85% of land that was in the hands of tribal nations shifted into the hands of whites. So that's our grandparents' time period. So we really have to understand how recent this is and what a huge shift that was, not just in terms of land, but also in terms of wealth, in terms of the ability to sustain yourself, and in terms of having a concrete location for your tribal community. In other words, a kind of home base or country for this tribal nation.